Supreme Court justices are being asked to consider the legality of the FDA's decisions surrounding the use of mifepristone. FDA regulators dropped the requirement that prescribers must see a patient in person before giving that medication. If the Supreme Court were to force the FDA to overturn that decision, it could impact all other approved drugs out on the market.
Chief Legal Analyst Khalif Rhodes is here. Of course, that hearing this week, the justices asked a lot of medical questions on this week.
Chief Justice Jackson, not Chief Justice, but Justice Jackson said it best. She goes, we're not professionals. We're not medical professionals nor doctors. And so attempting to turn us into doctors right here in this spot, I think would do a disservice to the medical profession and to the bench. What this is not on its face, it looks like an abortion type of case, but underscoring it is really government's approach to how these agencies can regulate, their ability to regulate and to create rules. And so most of the conversation circled around, does the FDA have this authority? Does it have this power? Is it limited? Do they have anyone else that they answer to? And I was happy to see that the majority of the justices seemed very open to the argument that the FDA does have this power and that you don't want to limit them because it could open some unlimited Pandora's box. However, there were two that were very cemented in their views, Alito and Thomas. They were very clear that, listen, they were skeptical of the FDA's ability to do these things and wanted to know where the history, the rationale for them having the ability to do this, and they seemed like they were willing and open to limiting it. The good portion of this argument is that the majority of the justices recognize that you need an FDA, a Food and Drug Administration, or the government kind of wouldn't work. Everyone needs a check and balance process. You need an agency out there that does this type of work to ensure that these drugs are checked and verified before they're put on the open market.
And so stepping back just a little bit, the FDA in 2016 and 2021, they made this pill, the mifepristone, more accessible. You could be delivered through a mail. You didn't have to go to a personal a doctor visit. Is this the Supreme Court going, maybe they shouldn't have that right? They should not have made it as accessible because there were a couple of examples where it might have been irresponsible or some pain and harm to patients?
So this is only here because right now, obviously, Roe v. Wade was overturned. So after the Dobbs decision, everything is now up for grabs in terms of what abortion. And so in the wake of the Dobbs decision, you had a number of states kind of ramping up their use of these pills. And so 35 plus states have access to individuals getting access to the pill. And in 16 plus states, you can go to a clinic and not have to go to a doctor. That's really where the argument is kind of laying. And when the FDA allowed it to happen in 16 and in 2020, revisiting that conversation of, well, should we even allow clinics to do this? Should you need an appointment at a doctor? Yes, there was a lengthy discussion about that very topic, but the underscore was, should the FDA even be doing this? But if we even talk about the whole argument, a majority of the justices said, how did we get here? Justice Kavanaugh probably said it best. He said, this is when you take a small lawsuit and attempt to try to rewrite laws. And that's not what the Supreme Court is here to do. Why are we taking this small case and attempting to make this now a national issue? And I don't think we should do that.
And there will be more discussion about this.